you need to think about who is going to represent you because it may be the most important thing you ever did. I didn't, thinking I knew the person I hired to represent me and that he, recognizing who I was, would have the kind of rapport that I'm talking about that should exist. And he didn't. And he didn't prepare. And as a result, I lost. Hi, I'm Robert Simels, and welcome back to Injustice for All. This is episode 3. And today we're going to talk about a couple of topics that I believe are interrelated. But before we start our main topic, which is how does an attorney win a case? And what should they do to help you walk away from any criminal charges? I was struck this week by the headlines in which former New York City Police Department chiefs were suing Mayor Adams and others within the New York City Police Department for having forced them to resign for what they termed bribery, corruption at the highest levels to elevate others to their position. Now, this struck me because corruption in government is nothing new, but it makes its ugly head known in the criminal justice system when we see those who advance, whether it's in the police department or on the judiciary or prosecutors, who really may be corrupted morally, ethically, in some fashion. And to that end, I saw yesterday that the person who has been nominated to be the U.S. Attorney in the Southern District of New York, the most influential, prestigious U.S. Attorney's office in the entire United States. Of all the 94, that's number one. But the person who was nominated, who was working for a law firm, earned $6.7 million last year from various clients, many of whom would be potentially the subject of investigations by the Southern District of New York. His response to that potential conflict of interest is, I won't participate. But if the head guy is not participating, why is he the head guy? And this is not something new. This happens all the time. We have seen it on various positions, not only in this administration, but everyone, that they're not vetted properly. And even when the Congress knows that they have issues, they just essentially ignore them and rubber stamp the nominations. Corruption has overwhelmed for centuries the criminal justice system, going back to the 1800s all the way to today, obviously. And one of the things we must keep in mind is that history tells us that about every 20 years, we get around to investigating that corruption. We'll talk first maybe about the 1930s. In the 1930s, the then governor of New York, the then president, Franklin Delano Roosevelt, realized that there was potentially a lot of corruption within the New York City Police Department. And so an appointment was made of a fellow named Samuel Seabury, an ex-judge. And he had what we call the Seabury Commission. He focused in on the magistrate's court, took testimony from 1,000 people, and discovered that the magistrate's court, which is primarily the principal court in New York City at that time, was corrupt from the bail bondsmen to the attorneys to the prosecutors to the cops and the judges. And among the schemes that were perpetrated during that period of time was the setting up of women by having a informant for, or stool pigeon for, the police make a date with a woman, and when she arrived at the hotel room, they would have money already planted there, and they would arrest her for prostitution. If you wanted to get out of it, you would pay the cops, you would pay the lawyer, you would pay the prosecutor, and you'd pay the judge and the bail bondsman. And this was an ongoing scheme that permeated the whole system, among other schemes by the police department to benefit financially. And then one of the women who was put in that position and put in jail for it wrote a letter to her husband and to the cop who had arrested her and said, "I'm going to expose what you all have done." And 2 or 3 days later, she was dead. How? Nobody seems to know. But this was part of the investigation into corruption that Samuel Seabury conducted. And when he saw the results of this woman dying, he began to look further. And ultimately, the mayor of the city of New York, Jimmy Walker, had to resign because they found that he had $1 million slush fund that he had been paid during the course of his administration. Going forward another 20 years, we had the Gross Commission that investigated corruption in the Queens precincts, police precincts. In the 1970s, 20 years later, we had yet another investigation, this one called the Knapp Commission, which is more famous perhaps than the others because you had what is now a celebrity, Frank Serpico, but Serpico testified before the commission, as did hundreds of others. And what the commission decided from all their findings was that the entire New York City Police Department, and maybe most of the criminal justice system, was corrupt. So the then governor, Nelson Rockefeller, appointed a special prosecutor to oversee all of the boroughs of New York City, over the individual district attorneys, police department, one person and his office to oversee and try to deter the corruption, clean it up. That was called the Office of the Special Prosecutor, and that existed for about 10 years. However, when it was prosecuting, and I was a member of that office, when we were prosecuting police officers, correction officers, bail bondsmen, even lawyers, we were heralded as the most important thing that happened to the city in decades. And then we started focusing in on the politicians and the judges and the lawyers, and we became public enemy number one. And so after a 4-year period of time, the then governor, Hugh Carey, fired the head of the office and replaced him with someone who tamped down the investigations. But you would say, how successful could it have been? It was successful, that is, the special prosecutor's office was successful because everyone feared us. They didn't commit crimes and misconduct, not necessarily because we caught them, but because they were fearful of being caught. And it was that factor that tamped down corruption within the system, at least during that period. But with the disappearance of the office, 20 years later, we had yet another commission. This was called the Mullen Commission, after the head of the commission, Milton Mullen, a very fine judge. And he found that there was rampant corruption in the police precincts in Queens, New York. Now, I'm not going to spend the entire show talking about the corruption that has been outed each and every time, every 20 years, because what it tells us is that unless monitored, unless there is a special prosecutor in place, it cannot be controlled, and it will continue to pervade the system. And if our law enforcement is corrupt, how can the system work? And the corruption is not simply I took a bribe. Corruption can be I did a favor. Corruption can be I altered my testimony from what the facts are to what I think they ought to be to get a conviction. And the latter, changing your testimony, molding it so that you can get a conviction, is the most endemic part of the system. And it's impossible to really control. But all we can do is continue to look at it and make arguments to the court and others that this has happened and try to overcome each and every instance where it does happen. And we're going to talk about such a case in a minute. Now, I don't know that we ought to have a special prosecutor in New York City. I don't know whether one on a national basis would work. We do know that all the inspector generals who were in place, who oversaw various agencies in the United States government, have all essentially been fired recently. So there's really nobody overseeing those agencies as to whether or not they're doing right or doing wrong. And more than ever, we've had politicians criticizing the criminal justice system, criticizing the FBI and the courts and the judges, and saying that they're corrupt or they're stupid or whatever they may be saying. But this undermines confidence by people in the system. Yeah, I understand. I have to, when I was practicing, I had to deal with this every time we picked a jury. Who was where were they in their thought process? And today we have the benefit of looking at their social media to sort of get an understanding of who the potential jurors are. But nonetheless, every day that the system is under attack is another day that you may have another person whose views about the system have been altered dramatically. The most important thing within the system, and this gets back to my original topic today, is how to pick an attorney to represent you, whether it's in a civil case or a criminal case. You must understand that not all attorneys are equal in their knowledge and abilities. Some are better suited for one kind of case versus another. Many lawyers specialize in one type of case or another. And yet, if you need a lawyer for a civil lawsuit to collect money, or you need one for a criminal case if you're in jeopardy of going to prison, who do you know that can represent you? Probably you don't know anyone. So who do you go to? Your friends, your family, what you saw on TV, what it says on Yelp, what it says on the internet. But those are not necessarily good gauges for who to hire. You may interview an attorney, and that attorney may convince you that they are in your corner 100%. They'll be there for you round the clock until the end. Every attorney, unfortunately, does that kind of dog and pony show for you. I'm there for you. I feel for you. I'm going to be there for you. But they don't mean it. And they don't mean it because they have other clients besides you. They're not thinking about your case 24/7. You are, but they're not. And so finding the right attorney is a challenge. But it can be done. You need to feel comfortable with the person who's going to represent you. You have to feel a connection that will allow you to have confidence in the person. You can look at their record. That will tell you something, but doesn't tell you everything, because you want to be able to communicate. I think this is a good idea. What do you think about this? Most attorneys don't want to hear from you after you've retained them, because they think they know better than you about how to do whatever the case may be, civil or criminal. And for the most part, while that's true that they know the system better than you do, they don't know the facts as well as you do. And any attorney who doesn't invite you on an open basis to communicate, whether by text, by email, by phone call, or letter, to them everything that you know about the case, everything you know about the people who may be witnesses, then the attorney is doing you a disservice. And so you want to ask the attorney, all right, how is our communications going to work once I give you this check? Are you going to respond to me? Can we put a clause into the retainer agreement that if you don't respond to me, you'll refund my money? You have to almost put a penalty clause in for the attorney to willingly agree that there will be this level of communication. I've been around this as system, as I've told you, for 51 years. And it's rare to see that kind of good relationship between a client and the attorney. So, if indeed you find the right person for you, and you have checked out their record, and you know what they look like, I mean, appearance is important. A jury's going to evaluate who's representing you because they're really going to look at that person as if they were you. When they speak, you're speaking. So look at the person and judge them and say, that's who I want standing in front of a jury for me. This is who I want standing in front of a judge. You don't want an attorney who will cower before a judge. Judges are nobody significant beyond the fact that they have been appointed or elected to the bench. They don't possess necessarily any more knowledge than your attorneys will. They are often biased, most likely biased. And the reason that they become biased is they become jaundiced. They sit on the bench every day. They hear the same kind of stories from attorneys every day, whether it's in a civil case or it's in a criminal case. In a criminal case, they say, well, my client's not guilty. This is he's lived 50 years and never been convicted of a crime. And the judge is thinking, to tell you the truth, yes, this is the first time he was caught. Not necessarily that he's been a pure citizen of the country for the last 50 years. This is the first time he's caught. And everybody who comes in as a defense attorney makes the same argument to the judges. He's got a family. Yes, he has a family. The judge is thinking he knew he had a family when he did or she did what they did. So know that they have these views. And worse than that, many of them are biased and prejudiced. Now, you may say, well, we've changed the bench. We're putting more people of color on the bench. That won't necessarily change the equation because when they sit on the bench, they all think the same for the most part. So let's get back to how you selected this attorney. I want to know, and you should want to know, how do you prepare a case? I see that you're personable. I see you make a good presentation. I hear you tell me now that we're going to communicate throughout the process, but how do you prepare a case? It's important because clearly one of the factors that dictates whether you may be found guilty or not guilty or win a civil judgment is the resources that you have at your disposal to be able to enable your attorney to do the best they can for you. You have to think about who are the potential witnesses who will line up against your cause, civil or criminal. You have to think about who could potentially help you. Now, you may say to yourself, well, I have these 20 friends who will vouch for me, or 20 colleagues, but they still have to be interviewed. They have to be examined as though they were a witness, and they have to be cross-examined to determine whether they will withstand an examination by the opposing party. So not all of the 20 people you think are great people will necessarily qualify to be a witness. The most important thing that an attorney will do for you, forgetting how they appear, forgetting how they present themselves to you, is their work ethic. If you want an attorney who can win, it's an attorney who understands that the key to winning is preparation, preparation, preparation. You get a document, you read it once, twice, 3 times, maybe 10 times. Because as you read each individual document that's involved in your case, it makes more sense as you integrate it with other documents you read in the case. You may see something in document 1 that criticizes, undermines what's in document number 10, and vice versa. And so if you're in a criminal case, for example, the prosecutors give you the reports prepared by the police in the state courts and or the federal law enforcement, FBI, DEA, in the federal courts. Those reports are a guide for you, but they're not able to be used as though that were the statements of the witnesses. And I'll explain to you why. First of all, any of you who have served on jury duty or have been in a courtroom know that that's a bizarre place. It's a place where nobody speaks English like you speak English. There are people objecting and people sustaining and people overruling. What does all this mean? So in that context, we also have to understand what constitutes a statement or not. So let's assume we're in a federal court and there's the FBI is the investigating agency. They prepare, or are supposed to prepare, they don't always do it, a 302 report, which is a report of what they say they investigated on that particular day. Now, nobody's recording what they're doing on those days. They don't have a portable recorder. What they do is they listen to what the person is telling them or what they've seen, and then they come back to their offices and maybe write it down, or at least their recollection of what occurred. And sometimes, as you will see in these cases, the report of that incident won't be written for 3, 4, 5 months. And you say, how can this person recall everything that happened? And they don't, but they write it as they think it happened, which is not necessarily good for you because it impacts in a couple of ways. One, when they give the report to the prosecutor who's trying the case, the prosecutor accepts this is what happened without knowing whether or not the agent may have recalled or not recalled, accurately reported. So you are subject, you, the person who's being investigated, to what it is that the agent wrote down as being the factual premises. Secondly, because it's the agent's recollections, you can't use those statements to cross-examine a witness in court because the person, if properly prepared by the prosecutor, and they will say, I never saw that report. I don't know whether it's accurate or not. It doesn't sound accurate to me. I think I said something else. Now, this is good for you if you're going to make the agents and the investigating component of the case the focus of your case, but it doesn't help you with the witness. So, getting back to my original point, preparation, preparation, preparation. Look over every report, see what the inconsistencies are. Try to flesh that out if you can before trial through what we call motion practice. That is filings that you make with the court that the prosecutors have to respond to, and maybe you'll get a better understanding of what the inconsistencies are. But it goes beyond just reports. Let's assume that you're in a criminal case and there are wiretaps. I'll give you an example from one of my cases. United States versus Payton. And in that case, the government had a wiretap on Claudine Jones's phone, which was located in Harlem in Manhattan. And they had that tap going for 2 months. At the end, when they went to prosecute my client, Mr. Payton, they gave us all of the recordings that were made. And there were hundreds and hundreds of recordings. Now, what generally happens with attorneys, because most of them don't prepare, at least not the way they should, is the government will say, hey, listen, we're going to offer these 20 recordings. And the attorney says, okay, I'll listen to the 20 recordings. But that attorney is doing you a disservice because they should listen to the hundreds of recordings that are involved, or however many there are. Because if the prosecutor is not using them, maybe there's a reason. First of all, the prosecutors haven't listened to them either. The agents have, or the cops have, and they've decided what's good for them. So, because agents and cops are the source for prosecutors, they rely upon them. They're busy with many cases, and they have to rely upon these law enforcement people to tell them what's there and what's not there. So when they tell the prosecutor, these 20 tapes are good, they prove our case, the prosecutor is unlikely, almost certainly not going to listen to all 200 recordings. But that's what a good attorney does. That's how you beat the prosecutors at their game. And nobody in the United States has ever had a better trial record of winning than I have. That you could check out. But that's not important. But the reason that I was successful is not because I was handsome or presented myself well or was glib in court. It's because I prepared. And when we got the 200 recordings from Claudine Jones, we listened to every one of them. I listened to every one of them. And then because I was detecting a pattern of things that disturbed me within the recordings, I decided that I needed a witness to explain to the jury what the lingo was that was on the recordings. And so I went to Kenneth Clark, the most noted anthropologist in the United States, and I said, how do I do this? And he said, you get yourself someone who now studies the topic called ethnography, the study of the urban culture, who understands not only what and how people speak within the urban center, but also what their customs are. I said that sounded fair. He recommended a couple of people to me. I went and spoke to them. I prepared a potential witness who was white. I prepared a potential witness who was black. And I had them both listen to all the recordings and give me their findings. And it would be subject to what the makeup of the jury was as to which one of them I would call, because they were equally talented. And what they told us was that they detected on the wiretap anomalies, things that didn't make any sense about what she was saying, but reflected language that was part of what we call the con game. They gave me examples of what she said that showed that she was conning the person she was talking to. And indeed, one of the main things that we learned, I shouldn't say a main thing, but one of the things we learned was that Claudine was talking to one fellow and saying, oh yeah, I'm here in Queens negotiating a deal for 5 kilos of cocaine. And I said, well, The prosecutor must recognize that since the wiretap was on her home phone in Manhattan, she couldn't be being recorded if she was in Queens. So she was lying to this person. And the more examples we came up with of her lying to people on the phone, the more we could undermine the veracity of the wiretap. That plus, ultimately, Dr. Terry Williams, who was the ethnographer who testified at trial and explained to the jury why she was lying. And I kept Claudine Jones on the witness stand for 8 days in cross-examination. On the 8th day, she fell over in the witness box and had to be taken to the hospital. On the 9th day, she came back and answered every question I wanted in the way I wanted, which was the truth. She surrendered. But if I wasn't that prepared on the wiretap, it would never have happened. And after a 3.5-month trial, a trial that nobody thought we could win, Mr. Payton was found not guilty. Now, I give you that example, but it's true in everything you do in this business. There was a case called United States versus George Rivera. I represented him as well. He was called Boy George. And on this wiretap in the Boy George case, the girlfriend, Lisa, said to Boy George, "Listen, I need paper to go see the doctor." The agent got on the witness stand during the trial and said that that conversation was clearly a drug conversation where she was asking for paper, money, and she was going to see someone whose alias was the doctor. However, had they listened to the recordings that took place over the next 2 weeks on the wiretap, they would have understood that indeed Lisa was asking for money so that she could go see a real doctor, and what happened when she saw the real doctor, because she reported back to George as to what the findings were and how the money had been spent. So when I confronted the agent with that fact on the witness stand, he was dumbfounded. Why? He didn't prepare, and the prosecutor hadn't prepared. And that's how we won that case. I say won. We didn't really win. George was convicted of a conspiracy, but found not guilty on the other 13 counts. The jury thought they were doing me a favor by only convicting him of a conspiracy, that it was a lesser charge, that it was a misdemeanor. But indeed it wasn't. It's a felony, and he received a substantial sentence. Again, my point being, if you look and read and evaluate every single document in your possession, you can win. I talked last week about the case against Nicole Daydone and Rachel Cherwitz. This was an extraordinary case to me from a defense position. The lawyers in the case had at their disposal some 50 people who work for One Taste, who over the course of 7 years had evaluated every single recording, every single videotape, every document that was involved in the case, and had assembled them into binders and other available materials for any of the attorneys who might try the case. This kind of preparation conducted by a client is unheard of. It's the first time I have seen this in more than 50 years. They were so well organized and they had everything available. When you have that opportunity, when someone has laid the case out for you, you then have to come up with a theory. And when a person represents anyone, civil case, criminal case, you have to say to yourself, if I have to try this case, what is it I want to say to the jury at the end of a case? Because that's how you mold your case. You say, I want to be able to say X, Y, and Z because that's my theory of winning. And how do I get there? What do I need? which witnesses, which documents. So we have manipulation. And FBI agents can be manipulated, and FBI agents can manipulate. A very famous case it was a fellow named Whitey Bulger out of Boston, who for decades manipulated an FBI agent named Connolly. And he did this by feeding Connolly information that Connolly could then make arrests with and look like a star. And at the same time, Connolly protected Bulger from being prosecuted. In the end, Bulger was revealed to be an informant, went to prison, and was killed there. And the agent, Connolly, also went to prison for accepting $235,000 from Bulger. So manipulation is part of the system. You, as a defense attorney, civil, criminal case, you have to know that. And you have to be prepared to address that and to be able to deal with that in your summation. In the John Gotti prosecutions, during the time when he was called Teflon Don, his attorney, very good guy, named Bruce Cutler, was viewed as one of the great attorneys in New York City because in 2 successive cases, there was a not guilty verdict. In hindsight, we now know that those 2 juries were bribed, and that's why they returned not guilty verdicts. But what Bruce would do, and many attorneys do, not just Bruce, is they get up there and they attack the witnesses and they say, "You're a yellow dog," and the witness says, "No, I'm not," and you say, "Yes, you are," and the witness says, "No, I'm not," and they say again, "You're a yellow dog," and you keep repeating it. And you sit down, and in the case of John Gotti, he would pat Bruce on the back and say, "Great job, Bruce." But when you attack a witness like that, "You're a liar, you're a liar, you're a liar," you won't necessarily ultimately persuade the jury that they're lying, particularly if there are multiple witnesses, as there were in Dayton. Were all 9 of these witnesses lying? I think they were, but for a different reason, and a different reason than was developed at trial. And the truth of the matter is, if you keep ingraining in someone a fact about themselves, whether it's being a victim or otherwise, you're not going to shake that simply by saying, "Hey, but didn't you say this? And didn't you sign a document saying I'm willing to do this course? And didn't you have a good time?" That's not going to make the case for you as the defense attorney. You have to have a way of showing that they've been manipulated. So how do you prove, or at least make an argument to the jury that's reasonable about the fact that these witnesses' memory, as they testified to at the trial, is not an accurate memory? You can't just simply say, "Your memory is not accurate." That carries some weight, but not much weight with the jury, even if they like the attorney. They may love seeing the attorney and see that the attorney is animated or is replete with facts that undermine the position, but 9 people all saying the same thing. Now, the way you undermine this is you call an expert witness to help you undermine it. You call somebody like the woman we expect to be our guest next week, Dr. Elizabeth Loftus, the leading memory expert in the United States. And Elizabeth will explain to you how that comes to be, because it's not true only in this case, it's true in almost every case. The prosecution, law enforcement, ingrain in a witness what they think they ought to say. There was a very famous witness back in the 1970s called Bob Lucy. A book was written about him called Prince of a City. And Bob was part of what they call the once elite, now defunct, Special Investigating Unit of the New York City Police Department, the most decorated detectives in the police department, who were in charge of investigating narcotic traffickers. The movie French Connection is based upon them. So ultimately, of the 81 members who were part of that unit, my office that I was part of, the Special Prosecutor's Office, and the U.S. Attorney's Office, prosecuted almost 79 of the 85 people because they were all corrupt. They all stole money, did other things that were improper, gave drugs to their informants. But Bob, Lucy, was considered the darling by the Southern District of New York. And they had him testify in a case. And then the defense attorney, Eddie Rosner, began cross-examining Lucy about other crimes he had committed other than those he had told the prosecutors about. And there was a pause in the trial, and the judge turned to the prosecutors and said, "You better find out if there's any truth to this." And over that weekend, they spent time with Lucy, and Lucy admitted, yes, I was protecting all of the members of my unit by only telling you about some of the corruption I knew. Normally, you would say, well, prosecutors should have charged him with perjury. But they didn't, because he served their purposes. And so he came back at the trial and he said, yes, I lied, but here's the truth. And here's what happened with everybody. And the person who was on trial was convicted. Lucy got a pass. And having dealt with Lucy myself over the years, you could say to Bob, hey, listen, your partner who's also cooperating tells us this. Oh, yeah, that's what happened. The prosecutors would help them get their stories straight. And that's what happens. Every case, it's unquestionable. I'm reminded of a case against a fellow who I represented named Michael Gasparic. And he was charged in a pump and dump conspiracy. That is, he was going to claim that his company was worth a certain amount, issue public stock, and hope that the stock was bought, and then sell off the stock and make a fortune, even though everything he was saying about his company was untrue. And so in the middle of the trial, the prosecutors produced someone from Boston who was the head of a financial institution, very well known. And as the head of it, he came down to the courtroom in the Southern District of New York in Manhattan. He got on the witness stand and they said, have you ever heard of Michael Gasparic? No. Have you ever heard of his company? No. Would you know as the head of a company? Yes. So on cross-examination, I had prepared, and I knew I had documents from his number two guy, letters to my client, proposals to my client, which show that they not only knew my client, but they knew his company and were working with him. So I asked him, do you know Mr. Jones? He said, yeah, he's my number two guy. Oh, where's Mr. Jones's office? Right next to mine. How often do you see him? Every day. We talk all the time. So is he authorized to do business on behalf of your corporation? Yes, he is. And he wouldn't have to check with you about every client that your firm is working with. Absolutely not. He's my number two guy. I trust him implicitly. Well, let me show you this letter. Do you recognize the stationery? Yes, it's our stationery. Do you recognize the signature? Yes, it's Mr. Jones's signature. Can you tell us who it's written to? Michael Gasparic. Let me show you this document. And we went on because we had collected and were ready for the witness. And it showed the jury that the government didn't know what the heck they were doing. Why put this guy in the witness stand? Why not have him do a search of his office to see if they knew about Michael Gasparic or the documents or the company? And because of that, and maybe because of the cross-examination of their informant, The jury found Mr. Gasparek not guilty in an hour and a half. Shocking, the prosecution. But listen, if you don't do all the preparation you should, you can't win. And if you don't do all the preparation you could, you can't overcome the government's immense opportunity that they have that you don't as a defendant to win. And again, let me remind you, when you're in a federal court, they call the prosecutors the government. They call the prosecutors the United States. And they call your client the defendant. And people initially all think the same. They're a defendant, they must be guilty. In the state, they call them, the prosecutors, the people against whoever it is. So that's an advantage. In the federal courts, you walk into marble corridors and beautiful wood in the courtroom. It's overwhelming to an ordinary person. So with those advantages, you, the defense, have to work harder than they do. And you can. All you have to do is do it. And so, getting back to my original point, you need to think about who is going to represent you, because it may be the most important thing you ever did. I didn't, thinking I knew the person I hired to represent me, and that he, recognizing who I was, would have the kind of rapport that I'm talking about that should exist. And he didn't. And he didn't prepare. And as a result, I lost. So, next week, we're going to have Elizabeth Loftus, and she's going to tell you more about what we've been discussing today about memory and how to present what really happened to a jury. So until next week, this is Robert Simels, and this is Injustice for All.